keep making. And before we start, there are going to be several times during the webinar where I'm going to refer you to certain references that are contained in our website. And I want to take you there just briefly. And the reason for that is we're going to be referring, this is the, excuse me, homepage for our law firm website. And there's an Ask a Question feature here that you can go on to, and you can submit any question you want for any jurisdiction, and you'll normally get an answer within an hour. There's a referral file feature here that's self-explanatory, which many of you already use. The subrogation charts is this is the most heavily trafficked site on any law firm in America, according to our webmasters. If they are to be believed, there is more time spent on this page here and on these resources than on any website, law firm website that is in America. So that's something we're pretty proud of. But I think it's a testament to the hunger within our industry for some answers to questions in a field within our industry that has become increasingly more complicated. Complicated within any one individual state, and then of course even more complicated when you have to meld the possibility of 50 separate, or 51 including DC, separate bodies of law that we have to be familiar with in our industry. So this is no easy task. You can check on any one of these charts, and you can, up here is a chart that discusses MedPay and PIP subrogation in all 50 states and has an introduction that talks about the different systems. It has a legend, and then it goes into each state, and as you can see, provides you with a summary of the law with regard to MedPay and PIP. Same is true for contributory negligence, comparative fault laws in each state. You can go in and find out what those laws are. And as you can see, this is an area that actually covers all kinds of different topics: damage to property without market value, recovery of sales tax, suspension of driver's license, subrogation of criminal restitution, imputing contributory negligence of a driver to a vehicle owner, anti-subrogation rule, workers' compensation claims by undocumented employees, and one of the most popular, of course, and this webinar will have a slant toward workers' compensation just because we have to speak in one vernacular so that it's consistent, but here's a chart that gives you a summary of the statute, whether and when the carrier can sue, and all sorts of answers to questions with regard to workers' compensation. So that is the website. These resources are free for clients, non-clients, future clients alike. So please avail yourself of those. And as I mentioned, I will be referring to those throughout the webinar. So let's begin as I get to the proper slide. This presentation is actually one that was first written by us and given back earlier this year at the ExecuSummit conference at the Mohegan Sun in Connecticut. For those of you not familiar with ExecuSummit, it's a great organization. When you go to a conference for ExecuSummit, it is literally the top executives, from claim VPs to board members to the higher ups who make decisions that affect all of our lives. And I found it very intimidating because although I've had 34 years of experience, my experience has been on the litigation side within private law firms. I have never run an insurance company. I have never managed a floor of claims adjusters. I've never had to set reserves. I understand the process with all of this, but this is sort of my way of saying, I'm sorry that this presentation takes on the intonation of advising clients about things they're doing wrong, because I have some wonderful clients and they do a lot of things right. But I think my mission here, it was sort of an epiphany of a collection of things that I see over the last 34 years, my clients doing wrong that has cost them a great deal of money. I don't know the business of insurance better than anybody who makes a career of it, but I do know subrogation pretty well. And I see the problems, I see the missed opportunities, the blown statutes, the failure to give notice. I see incorrect assumptions about subrogation law. I see dilatory tactics, procedures, procrastinating that costs literally millions of dollars to my clients over the years. And I figure that we can work together better if we're communicating. So 33 years of representing the needs of insurance companies, self-insured, subro vendors has distilled 10 of the most repeated mistakes I see insurance companies making. This isn't intended by any stretch of the imagination to be a criticism or an indictment of my clients, because I have some clients who do one of these wrong. I have some clients that do all 10 of them wrong. I have chosen these 10 mistakes in the order of frequency and seriousness. That means that the number one mistake we're going to talk about is the one I see most frequent, combined with the seriousness of the mistake. Not putting enough postage on a piece of correspondence is a mistake. It's not one we're going to mention here because it is inconsequential to subrogation recoveries in most instances. Instead, these are going to be mistakes that literally cost a recovery in 1, 10, dozens, or hundreds of cases over the course of a year. Each of these mistakes that we're going to talk about could be considered a symptom of a company that perhaps doesn't recognize the value in subrogation, or that doesn't treat it as a wise investment of time and money. If you're listening to my voice, chances are you have some degree of subrogation responsibility in our industry. If that's true, then you know, as I do, that subrogation often isn't given at face value the sort of respect, time, attention, and dedication of resources and money that perhaps it should merit. I've always said that good judgment comes from experience, and experience comes from bad judgment. And there's no better proving ground or laboratory for this aphorism than perhaps the subrogation floor, the subrogation department, the recovery department. As Oscar Wilde once said, experience is simply the name we give our mistakes. So let's talk about some of those mistakes. The number one mistake, and perhaps it comes as no surprise, is waiting too long to involve subrogation counsel. Now, I could change that to waiting too long to take subrogation action, waiting too long to forward to the subrogation department, waiting too long to call our subrogation vendor or in-house counsel. But because I am subrogation counsel and ultimately the buck stops here, I've decided to name the first mistake, waiting too long to involve subrogation counsel. And there is a serious delay of game penalty that I see as a result of this mistake. And it is a repeated mistake, and it is simply a byproduct of human nature. We are all busy. We all have lots of claim files. I have given a lot of seminars, webinars. I've appeared at a lot of conferences over the years. I have yet to have one hand raised when I ask, is anybody not busy enough? One of the unfortunate fallouts of subrogation is that when you're handling a claim and all that entails, responsibly attacking subrogation potential in the way that it should be attacked in order to maximize your recovery is an investment that we often shy away from. If we can send out one demand letter or 2 or 36 and still convince ourselves that we're pursuing subrogation aggressively, that's what happens. Conservatively, 25% of the referrals we see here, both at our Wisconsin firm, when we handle subrogation nationwide, as you all know, or the New Orleans office or our new California office, 25% of the referrals we see are sent within 30 days of the statute of limitations running. Either subrogation isn't recognized in those 25% or it's not valued. There's no third option. I understand a lot of our clients would like to avoid engaging subrogation counsel, and I see how much that costs our industry in a lot of cases. This there are not cases where I'm not talking about cases where subrogation is recognized late. That's going to be mistake number 2, and it's a mistake of a different nature. It's one of commission as opposed to omission. This number 1, waiting too long, is an act of omission. There's no action taken. The impulse is to avoid getting counsel involved and to avoid fees, and with every month that ticks by, the value of the subrogation case is reduced. The chances of a settlement which bars our recovery is increased. Notice deadlines are expiring, and in some states there's as little as 30 days that we have once we are aware of a third-party case, in the case of workers' compensation, in which we have to act. And those 30 days tick by faster than you can imagine. We received a file, and this was coincidentally about a week after I presented this for the first time in Connecticut. I received a workers' compensation subrogation file involving high 6-figure lien and significant reserves, with 31 demand letters, approximately 45 days apart, sent out over the course of several years. The case settled 2 weeks before it was sent to us, and despite litigation, despite an appeal to the Court of Appeals in Texas, we were held to have been barred. And a release can bar us, latches can bar us, equitable considerations in certain states can bar us. So this mistake of waiting too long isn't limited to small files. I've had that case with 31 demands, as I mentioned, was a high 6-figure case. So when a fuse is short and deadlines passed, releases are signed, witnesses disappear, money is lost. And it's very important that these claims are handled properly. We're here to answer questions. If you have concerns, let us know. If claims handlers, subrogation professionals see subrogation and don't act, a lot of times it's a systemic problem. It's because they are not encouraged to, or because they don't recognize it. If the former is the case, the problem is systemic. If the latter is the case, then subrogation continuing education such as this can help. But make a habit to get subrogation counsel involved, even if it's just to review a file. I don't want you to handle this file yet, but what do you think? 1/3 of 0 is 0. 2/3 of anything is much better. I just say that because we see this the most often of any mistake, and if subro is referred late because it's not recognized, well, that's the second mistake that we're going to talk about. Subrogation, successful subrogation, is never an accident, and it's no coincidence. In fact, it's literally one of the few correct uses of the word irony that good subrogation programs are made better with mistakes. It's not just our money. Remember that. And in a growing number of states, legislators are requiring subrogation recoveries to be linked to and considered in underwriting procedures and calculating risk modifiers and loss histories. So we have a duty to our employers in workers' compensation settings to aggressively pursue subrogation. So what's the other reason that a file might not be referred timely? Well, I call it the hot cup of McDonald's coffee, and you may ask why. Quite often, the reason a file isn't referred is because there is a failure to recognize third-party liability. One of the inevitable drawbacks of our industry is one of our greatest strengths. We are all, at some point, trained to limit liability. We review our policy, we follow the terms, we pay covered losses, we deny covered losses that are not covered. We do not pay things we do not owe, and we pay things we owe. We are programmed, we are wired to limit liability. Subrogation is just the opposite. There's a requirement that we think like a trial lawyer, like a plaintiff's lawyer, like the guy you see on TV having you dial 777-7777. It's almost a necessity that we think creatively and think out of the box when it comes time to recognize third-party liability. Another good reason to rely on subrogation counsel. Is this a good case? Our insured, who was seriously hurt, was traveling down I-95 at 65 miles an hour and rear-ended a cement truck. Do we have a case? Everybody within the sound of my voice is thinking, well, of course you don't have a case. Your employee rear-ended a cement truck. Yet one of the largest recoveries we've ever had, and this was a Texas case some 15 years ago, was a case with exactly those facts. And we had an employee traveling at about 5:15 a.m. in late fall with no moon, no street lights, and they came at about 65, 67 miles an hour, and they came across a cement truck traveling at about 20 miles per hour, 19 or 20, and we got the black box, and we figured out that he had been in second gear for nearly 2,000 feet. That's over a third of a mile. And both taillights, which were 2.5 inches in diameter, were crusted over with dried cement. We made a great case and convinced the jury that the average reasonable person, including them, could well have been injured in the same way, even though they were paying attention. So this is the hot cup of McDonald's coffee situation. It's the case that is perhaps the poster child for tort reform. It's the most ridiculous case we can think of, because who in the world wouldn't expect a cup of hot coffee to be hot? And it reminds me of a story in Houston where I was practicing 20 years ago, and I was a partner in a law firm down there, and my subrogation practice was centered out of Houston, Texas. I was hired by a major workers' compensation carrier, a national carrier, who had an employer whose employee was traveling for business and was involved in a single car rollover. As a result, the roof crushed when the car rolled over and the vehicle went off the highway and snapped the neck of the employee. He became a spastic quadriplegic, and after about 30 days, he died, but there were significant monies paid out, and we were engaged to subrogate. Well, how in the world can you subrogate? There was obviously no one else involved. He drove off the road. I don't know if he fell asleep. We did a lot of research. We hired a forensic accident reconstructionist, an automotive mechanic, a design engineer, an ex-General Motors. This was a General Motors vehicle safety design engineer, and we determined there was a crashworthiness case which we could make a reasonable shot at against the manufacturer. Again, this puts some of us outside of our comfort zone, but for effective subrogation, you have to take off your claims hat and put on your subrogation hat. And I had to meet with the widow of the deceased employee and explain that we were pursuing this, find out if she was represented. As it turns out, she wasn't. And I brought a lawyer into my office who worked out of Clear Lake, Texas, but also had a practice out of Albuquerque, New Mexico. And the widow and I were meeting with the attorney in my office, and I explained that I was going to try and subrogate against the manufacturer. And I said, "Are you represented? You definitely have a claim under Texas wrongful death survival statute. Are you going to pursue it?" And she burst into tears and said, "I've talked to some lawyers, but what I want is," and this is what she said, "I want a lawyer like the lawyer who tried the McDonald's hot coffee case, because my husband deserves that sort of aggressiveness and creativity in his case. I know it's not an easy case." I tapped her on the shoulder when she gathered herself, and I pointed across the table and I said, "Please meet Reed Morgan." Reed's a friend of mine, and he's also the lawyer who tried the McDonald's hot coffee case. He represented Stella Liebig, who was 79 years old, who was driving with her grandson was driving the vehicle, and after she got her coffee in the drive-thru, they pulled over and stopped and put the car in park, and she placed a cup of coffee between her legs in order to take off the top and add some sugar and some cream. And the cup collapsed, causing third-degree burns to 6% of her body, including her groin area, skin grafts, burn debridement. The attorney, Reed Morgan, asked McDonald's to pay for the medical expenses, and they declined. He filed suit. They determined through discovery that McDonald's serves coffee. Then at approximately 180 to 190 degrees, and at that temperature, third-degree burns result to human flesh in less than 2 to 7 seconds. Other restaurants normally serve coffee between 135 and 140 degrees. The McDonald's quality assurance manager admitted it wasn't fit for human consumption. The quality manager angered the jury on the stand by indicating that, yes, there were 700 and counting injuries, but they weren't going to change their practice because their coffee sales were $2.7 million a day. And their marketing folks had determined that the smell of hot coffee was something that really drew people to the coffee, and so the jury awarded $160,000 and $2.7 million in punitive damages, which is 1 day's sale of coffee. The judge reduced the damages and the award to a total of $480,000, and they didn't even pay that. They ended up settling for an undisclosed amount. Reed told me the amount, but the point of the story is it isn't always what it seems like. Just because we are inclined to think our employee or our insured was negligent, we have to think more like a plaintiff's attorney. We also have to become familiar with the tort laws. We have to understand when a product liability action is available. We have to understand when we have a right of recovery and what the contracts say. And we have to understand comparative fault before we see third-party liability. And if you recall, when we were looking at the charts on the website, the comparative fault chart there is a good starting point. If you're in Alabama or North Carolina or peer contrib states, you're going to think a little bit differently about your insured's or your employee's fault than you will in a state where you have peer comparative fault, where even if your employee is 99% at fault, you can still recover 1% of the damages. So we need to think more like a plaintiff's attorney. We need to rely on subrogation counsel, not just to pursue your claims, but to help you recognize them. Subrogation training is important. We have a webinar. You can go. It's archived on our website. It is free. Recognizing third-party liability in workers' compensation settings. There's also one on recognizing subrogation. It's a first-year law school torts class. Hard work. Subrogation training will not guarantee success, but a lack of it guarantees a significant loss of dollars. So now we move to the third mistake that I see. And again, these are in the order of both frequency and seriousness, the effect that they have on our subrogation recoveries and the catastrophic losses that I see. And I want to mention, just as we're getting past the recognizing subrogation topic, a truly ironic fact, at least for our firm, the top 5 recoveries, and by top I mean the largest recoveries, and they have all been 8 figures in terms of lien recovery and or credit and or property losses. The top 5 have all been in cases which were originally marked no subrogation. 4 of them came from in-house file reviews, which we do for our clients. And one was a supervisor just said, wait a second, are you sure there's no subrogation here? We were asked to get involved. In a few of them, we engaged some experts in some preliminary investigation. We upfronted some costs and spent some money in order to determine if there was subrogation. But that fact, that ironic fact that 5 of the largest recoveries are in cases that were marked no subrogation. 3 of them were from Lloyd's, the Lloyd's market, and some syndicates that we represent either directly or through claims vendors. So that's an interesting fact. But in every file, the burden of proof is the same, and nobody is going to do it for us. In every file, that we get and want to pursue and want to recognize and act on subrogation, we have to prove that the defendant was negligent, that the product was defective. We have to prove that there was negligence which caused the damages, and then we have to prove the damages. So the first hours and days after a loss are critical. We do not do a good job of investigating. We do not do a good job. Overall, there are exceptions, and I've got some clients, I have clients who have 20 years plus litigating defense cases in California who are extremely knowledgeable and good at what they do. But I'm just speaking in general that we as an industry do a terrible job of investigating losses. We often don't see the purpose in it. We don't see the benefit or the gratification of having to bend over and pick up pebble after pebble. So as I tell you here that you should do more than you think is necessary and then a little bit more, it brings me to the parable of the pebbles. Some of you have heard it, some of you haven't. But it goes like this. One night, a group of nomads were preparing to retire for the evening after traveling through the desert on their camels when they were suddenly surrounded by a great light. They knew they were in the presence of this God-like celestial being, and with great anticipation, they walked out of their tents and awaited a heavenly message of great importance that they knew was especially for them. Finally, the voice spoke in a deep, booming voice. It said, "Gather as many pebbles as you can, put them in your saddlebags, travel a day's journey, and tomorrow night you will find yourself both glad and sad." The voice stopped. The light faded. Things went back to normal. And after the voice left, the nomads looked at one another and they shared their disappointment and even their anger. They had expected some revelation of great universal truth that would enable them to create wealth or health or happiness, something with purpose, but instead they were given a menial task that made no sense to them at all. They were told to fill their saddlebags with pebbles. However, the memory of the brilliance of their visitor caused them each to pick up a few pebbles, put them in their saddlebags while voicing their displeasure, and they went to bed. The next day, they traveled a day's journey, and at night, while making camp, they reached into their saddlebags, and to their great astonishment, they discovered that every one of the pebbles they had picked up had become a flawless diamond. Instantly, they were both glad and sad. They were glad they had stopped to pick up a few pebbles, but they were sad that they hadn't stuffed their saddlebags full with those pebbles. Subrogation investigation is like the parable of the pebbles. You do not know whether or not the photo you take, the statement you take, the evidence you secure is going to play a role in helping you recover 100% of your subrogation dollars. But if you don't, I can assure you it will not help you do that. And quite often, it could have helped, and even equally often, it sometimes hurts our subrogation cases when we don't secure the evidence, we don't ask the right questions. Okay, witness, this is being recorded with your permission. Tell me what happened, and you get a bunch of run-on sentences with ands and uhs, and okay, do you have anything to add? Thank you very much. Have a good day. That's not a statement. Prod someone's memory. Ask what happened next. Ask the tough questions. Were you distracted? Did you look down? Did you hear anything beforehand? What was the temperature? What time? Ask all of the questions. We have another seminar, as I mentioned, on investigation of losses that goes into checklists and things, and perhaps you have checklists within your company. Great. Follow them. We can get lazy on this mistake number 3 here, and it often costs us a lot of money. It's important in work comp cases to talk to the employer. You know they want to kill the case, right? They want to blame the employee. Why is that? It's because they don't understand. Not only have they never heard the word subrogation, they have no idea what it means. The first thing they're thinking of is, I worked 30 years to build this business, and now because this knucklehead got himself injured, I might lose it all? No, explain to them how subrogation works, how they have the exclusive remedy, how they're immune from tort liability, and how helping you helps them. It sounds like the line from, what was the, Jerry Maguire. Help me, help you. Help me, help you. You're helping them because they have no idea that helping you with the subrogation recovery will help them avoid significantly increased insurance premiums for comp in years to come. Lock witnesses into position. If you have a slip and fall case, it's almost worthless without some investigation. Every jury on a slip and fall case says the same thing. Well, I've been on ice. I walked on ice to get to this courtroom today. I didn't slip and fall. The employee must have been careless. Sometimes we're lucky. I have a slip and fall case involving a lady at a car wash who was washing her truck, and she walked outside, and surveillance camera picked up her slipping on the ice. She's walking very slowly, and literally her feet just go off from underneath her. It could have happened to anybody. But what the camera caught after that was even more valuable. As employee after employee came to help her because she struck her head and was seriously hurt, they too fell. These are things you don't even think of. Okay, how did you fall, ma'am? I slipped and, it was icy and I hit my head. Okay, well, thank you for the statement. Whoa, there's a whole lot more valuable information there that we have to get. Livestock on the roadway. One of the books that we have authored, and many of you are familiar with our books. I'm not peddling them because we don't make enough money on them. But automobile insurance subrogation in all 50 states, work comp subrogation in all 50 states. We have an insurance coverage book, ERISA and health insurance. There's also one entitled "Where's the Beef?" It's got a picture of a cow standing on a road next to a sign that says 80-mile-an-hour speed limit. Back when that sort of thing existed, and it may actually exist out in Wyoming. But the point of it is, where you have livestock on the roadway, we will not recover unless we can prove negligence on the part of the landowner. There are very few jurisdictions, and less every day, fewer and fewer every day, where there's strict liability for livestock that gets loose and is standing on the roadway. In fact, in some situations, this turns into a liability case because the motorist can be at fault, depending on the facts. And a cow is valuable, a steer is valuable, and some of them are very valuable. So it's important that we find out what happened, get out there right away before the farmer, the ranch owner, the cattle custodian has a chance to fix the broken latch on the gate that was open, before they have a chance to repair the rungs on the fence which were broken, or the electricity which was turned off on the electric fence. We have to know how they got out. We want to know from the neighbors, have they been out before? Yes, they have. We've warned them that there's a low spot that the cattle can literally walk right underneath the fence. These are things you have to know. Product liability. We want to preserve evidence. We have to pick up the pebbles. If you find that there's a toaster oven that you think made by General Electric that probably caused the loss, I can guarantee you the other side is going to blame the coffee maker and the can opener that are on either side of it. Pick those up too. Pebbles. You want the pebbles. Because any one of them could become a flawless diamond that's worth its weight in gold, literally, in these cases. Spoliation is big business. Defendants love to argue that loss scenes are spoliated. If you have a significant loss, if you have an injury scene, it's important that it be organized, that parties are put on proper notice. Municipalities are given the right notice, that you have investigators come out, that no destructive testing is done. Nothing is changed until all parties have a chance to be there, that we have the right experts, which we're going to talk about because it's another mistake that we made. You can't kick this can down the road. The reality is that there's a lot of money being lost because we don't take the time to pick up the pebbles. It's reality. And Ayn Rand once said we can ignore reality, but we cannot ignore the consequences of ignoring reality. So what are we going to do about it? That brings us to the next mistake, which is getting what you pay for. 15 years ago, I would say 15 years ago, this maybe would have been number 10 or maybe gotten honorable mention. I have a few of those at the end of the webinar. Getting what you pay for has to do with using cut rate vendors and low bidders. and how it is more expensive and more costly to save money than not. It's counterintuitive. And here is where I get into some trouble, because it sounds like I'm preaching to hire the law firm at the 25.33% contingent fee. A lot of times vendors will come and they will bundle claims handling along with subrogation. And guess what? I represent them, and they're in this audience, and they are good. I'm not saying that every vendor who comes in and says they can handle your subrogation for 22% is bad. I'm not saying they do a bad job. What I am saying is that some of the best intentions, i.e. cutting costs, saving money for your shareholders, has unintended consequences. And it is an irony, and this webinar is filled with irony. It is an irony that with best intentions of cutting costs, often you cost and lose more money than you save. All businesses try to save money. There's nothing wrong with that. There's nothing wrong with focusing on attorney's fees, litigation budgets, use of in-house counsel, litigation management guidelines, vendor databases, requirements that this expert be used on every case as opposed to that expert. These are all efforts made to contain costs and save money, but they have consequences. And those consequences are very real, and I see it, and the fact that I see it results in this being mistake number 4. Often we forget the real total cost of cutting corners. I actually angered a client who had an executive at the Executive Summit Conference earlier this year, where I presented this webinar for the first time. And he said, "Gary, it sounds like you're condemning what we do. We are a subrogation vendor." No, I'm not. If you do what you do right, and you are effective at it, that is great. And I urge clients to use you instead of me or other subrogation counsel. But the problem is we're forgetting the total real cost. We're not bidding on a fungible product with known dimensions and specifications. You're not saying, hey, I'll take that 2018 GMC pickup truck for $22,000 as opposed to $24,900 down the road. I'm getting a better deal because it's apples to apples. But subrogation representation, be it through a vendor, be it through in-house counsel, be it through a law firm such as Matthiesen, Wickert, and Lehrer, is a specialized personal service. John Glenn once was asked how it feels to be on a rocket, as he's about to be blasted off into space, and he said, well, let me ask you this. If you're sitting on something with 2 million pounds of jet fuel, rocket fuel, with 2 million moving parts, all built by the lowest bidder, how would you feel? It's a tongue-in-cheek comedic way of saying, be careful, because the trend today is to hire cost containment specialists who have to justify their existence. You get what you pay for. Litigation is rarely cheap, but it is often necessary. You have to go into every case with the idea that you're going to have to try this case. And so if you end up engaging a vendor at 22%, and then we'll handle all your subrogation for 22%. Wow, what a deal. That's better than a third. It's better than 25%. Is it? Because now when the case is met with a stonewall liability adjuster on the other side and you have to file suit, now they're searching the alleyways for a lawyer who is willing to handle a case at 22%, a $40,000 loss that they understand is going to take a minimum of 150 hours to prepare for and try, and that's the average. If you take even $150 an hour, which is actually low, that's a total of $22,500 that attorneys, that a firm, a business like yours has to invest in the file. So if you give the $40,000 case to a vendor at 22%, they only have $8,800 that can be made on a fee. And an attorney, if they then refer to an attorney for an even lower percentage, that attorney could be working for $50 or even $25 an hour. That isn't going to happen. It may happen once or twice or for 6 months, but ultimately, those are the cases where you get the bad reports. They're not aggressively handled. You get the reports on, the case is kind of bad. They're offering $5,000. I think we should take it. So a case will settle for a fraction of its value. In the case of the $40,000 loss, let's say it settles for $15,000 minus $3,300 for a fee at 22%. That's $11,700 you've netted. If you've got lawyers on the case that can spend a lot of time on it and it sells for $35,000 at a third, that's $11,666 fee. The net recovery is $23,333. It's over twice the recovery. So these are the files. Remember, I represent a lot of vendors, and they do a lot of good work, and they serve a valuable purpose. But you have to be realistic about when it's time to pull the trigger on a file, because these files do not get better with age. I've seen, like I mentioned, a lot of files were just a lot of demand letters sent out. So vendors come to us to handle cases that have been sitting around for 3 years. There's 30 days left before the statute, or even less, and it's really hard for them to find subrogation counsel. I often use the analogy that the real cost of eating fast food never appears on the menu. There's a quote from a businessman, John Ruskin, infamous businessman, who said, and I'll quote, "It's unwise to pay too much, but it's worse to pay too little. When you pay too much, you lose a little money. That's all. When you pay too little, you sometimes lose everything, because the thing you bought was incapable of doing the thing it was bought to do. The common law of business balance prohibits paying a little and getting a lot. It can't be done. If you deal with the lowest bidder, it is well to add something for the risk you run. And if you do that, well, then you have enough to pay for something better." Moving on to mistake number 5, sleeping with the enemy. You can see the clip from the Julia Roberts movie that many of us are familiar with. And there's a big temptation in the industry today to call the plaintiff's attorney, and I'll use work comp as an indication here as an example, an employee's attorney. You call and say, "Hey, are you prosecuting this third-party case?" "Yes, I am. Would you represent my interests?" There are cases where this is appropriate. In fact, one of the most effective techniques we use is, especially in cases involving unrepresented employees, is I will get the client's permission, find a well-known trial lawyer in the vicinity of where the litigation is going to occur, advise him that I can refer a client to him if he will agree to stipulate in writing to payment of our lien in full with no cost, no deduction, no pro rata share of fees or expenses, and literally we can just sit back and wait for our money. These are extremely profitable ventures, so we do coordinate and have a list of trial lawyers around the country that we work with. But the optical illusion here is the savings you'll never see and may never know you didn't see them. Plaintiff's lawyers, again, now you're going to be relying on somebody who has a conflict of interest, especially in work comp, where the attorney for the employee has a duty to maximize the employee's recovery and also maximize your recovery. This is counterintuitive. So trial lawyers are very clever. They know their victims. They are ethically bound to zealously make sure you recover as little as possible. One of the ways they can do that, and I don't mean to impugn all trial lawyers, there's a lot of good ones out there, but it's a zero-sum game. There is a finite sum of money that's going to be recovered, and two parties want to maximize their share of it. So everything always goes right up to the point where it doesn't. The plaintiff's attorney is arguing you don't have a right because they're not made whole. The plaintiff's attorney is arguing the case is horrible, and if you don't take $1,500 on your $300,000 work comp case, the plaintiff's going to drop it. Well, now you're powerless. Now you're not even a party in the lawsuit. The attorney will tell you that witnesses have fled or they did a horrible job. You have no way of knowing whether he's telling you the truth or coloring with a different colored crayon that you've never seen before. This is trial lawyer 101, and I'm glad they do it. They represent their clients as aggressively as they can. But I see these files frequently. Our attorneys see these files right up until the point where there's a settlement, and all of a sudden we're saying, hey, I thought you were representing us. Well, I didn't have a written agreement with you, and it's required in our state. So there's a lot of these cases where, well, I understand you have a lien. I do want to represent you, but unfortunately the wife is getting 75% of the claim, so there's very little left. What? Yes, we're giving it to her for loss of consortium, or we're paying all the money to beneficiaries who were not beneficiaries under the work comp claim, common law wife for adult children. So if you must, or if the case is, and it would be a good idea to use plaintiff's counsel on a case where it's just not cost effective, where you have a small lien. And again, there are states where you have to have counsel. In Wisconsin, for example, if you're brought in as an involuntary plaintiff in a complaint, you have to appear. But if you must use plaintiff's counsel, of interest, guess what happens to them? And when you cite him the rule in the bar opinion that says that, you'd be surprised how frequently he comes up and offers you a significantly greater amount. So sleeping with the enemy is something that we have to continually be aware of. Only in the rarest of circumstances should it be done. Now, mistake number 6, I call it detecting and curing subrogation cancer. Remember the Pebbles. One of the things we want to pick up and put in our saddlebags is we want to make sure to obtain copies of all contracts, all correspondence between our insured, the employer, any third party, the general contractor, the owner of a project. I want to know what terms are in that. Do we have indemnity? Have we agreed to waive subrogation? And in the case of a waiver of subrogation, the mistake I see very often is all of a sudden the file is simply closed. Well, why was it closed? Well, it was closed because we had a waiver of subrogation, Gary. Here it is in paragraph 9.6 of the contract our employer signed with the owner. It says we agree to obtain a waiver of subrogation endorsement in our work comp policy so we can't pursue the claim. Oh, okay. I am involved in drafting an amicus brief for the National Association of Subrogation Professionals in a case in Texas right now, in which just such a waiver, such as CG 24040509 that's shown on your screen in front of you, was used, except the one for work comp. And what's interesting is, in that case, we're arguing that you can't just look at the waiver endorsement. You have to actually look at the contract between the parties, and it becomes part of the policy. And we're arguing that there was no waiver, because even if there is a waiver requirement in a contract, don't close your file, because the waiver is something that only you as the insurance carrier or your client, the insurance carrier, can consent to. You have to consent to waiver. The employer can't do it. And if the only way you can consent is by providing an endorsement to your policy which says, I consent. And that endorsement is the waiver of rights of recovery against others. And that waiver now becomes part of the policy, and it indicates that you have consented. But don't close your file yet, because the waiver of subrogation endorsement has some conditions. In it, there's a schedule. It indicates when that waiver applies. And it may say, and normally does say, it applies only when we are required in writing our insurers contract, and because the waiver is required in writing, it's a valid waiver, so now it's time to close your file. But wait, not so quick. Now there's a schedule. Now the waiver endorsement says you're only going to waive subrogation as to the name of the person or organizations listed below. Well, it would behoove us to look at that. Who are we agreeing to waive subrogation for? Sometimes it includes the name of the general contractor or the owner, but sometimes it's other affiliated entities, and it's not the exact same corporate entity. And guess what? We haven't waived subrogation against the actual corporate entity that's trying to insist on waiver. Or the schedule could indicate scheduled operations that the waiver is good for, when in fact the injury happened in a different part of the construction project having nothing to do with those operations. Okay, so that's another out. So, but now if you check all of that and it looks like, okay, we waived subrogation, it's the right operations, we have the right entity, we're at a dead end, I don't even need to call Wickert's firm because we're going to close this one down. I've been handling these claims for many years. There's a waiver in place, not so quick. Now you have to ask yourself the question, okay, what have you waived? Well, look at your screen. Waiver of transfer of rights of recovery against others. What is that? That's subrogation. So maybe you waive subrogation, but what about your right to, drumroll, reimbursement? And there are some jurisdictions where that is an issue. Okay, maybe I'm entitled to, it means that I don't have the right to sue these other parties in subrogation, stepping into their shoes, the shoes of the injured worker, proceeding against the general contractor for negligence of their employees. Maybe I don't have that right, but maybe I have the right of reimbursement. Okay, but no, wait, I've read Wickert's book, and it says no, in Arizona, the waiver of subrogation, in Texas, it means both a waiver of subrogation and a waiver of the right of reimbursement. There's a court case. And in Texas, there is one. I argued it to the Dallas Court of Appeals. And it says a waiver of subrogation waives both subrogation and reimbursement. So now you close your file. But wait, not so quick. Because even then, what about your right to a future credit? You may have paid out $40,000, but you've got reserves of $300,000. And this case is settling rather quickly, or it's a death case and you've got to pay out until the kids are 25, all of a sudden you're talking about hundreds of thousands of dollars and they're recovering millions in the settlement. I would like to close that claim. I'd like to work on something else when I come into the office every day. Can I take a reserve takedown and close that file out and claim a credit? It depends. California? Yes. Texas? No. So it depends on the venue. But you can see we're way, way, way down the rabbit hole. We've picked up all of these pebbles. We've done everything we proactively can. And now, if you discover that you've waived subrogation, do you close your file? Maybe. Because now the other side has to do the legwork we did. Put them on notice. You want your subrogation interest. What will you waive subrogation? Well, let them do the mental mechanics, the mental gymnastics to come to the same conclusion we did. The other thing with regard to indemnity is, okay, let's say you have indemnity. Let's say employer liability claims are involved. In Illinois, for example, one of the crazy states where, even though the pact we made with so many years ago was that employers wouldn't be brought in, they are now being brought in, and there's the possibility of fresh money being paid, if you can believe that. Well, okay, what does that mean? Should we waive subrogation? No, because now it's an important tool, and it helps you with the employer liability claims. And when I'm handling cases in states like Illinois, a lot of times I'll enter into a contingent fee, which talks about recovering an amount for the reserve takedown, because I'm not even trying to recover money. Now I'm trying to save the carrier money under the EL claim. So we have to evaluate our business relationships with parties to whom indemnity runs, and remember the parable of the pebbles. Thorough investigation requires getting copies of the contracts, and the policies, we have to know what it is we're dealing with. Sharing the good news. No, we're not going to get religious. We're not talking about the newspaper. What we're talking about here is giving proper notice to all parties, giving notice to carriers, to government entities, to product manufacturers, to plaintiffs' attorneys, defense attorneys, top attorneys, local towns, villages. One of the simplest and easiest tasks is the one that I almost most frequently see done incorrectly. Some states require notice to carriers, notice to plaintiffs' attorneys, notice to liability carriers within as little as 30 days. Take Iowa, for example. Some states require notice to municipalities, like the city of Austin, state, for example, in their charter of 30 days. 30 days isn't, that's even shorter than your diary. You know, you can lose a significant subrogation interest before you even know it. And it really presents a procedural trap for the unwary and the unrepresented subrogation professional. So notice to a carrier triggers a law regarding the effect of a waiver. The notice to plaintiff's counsel triggers ethical responsibilities. In what do I mean by that? Again, we're down the rabbit hole, but notice to plaintiff's counsel. We have a lien. I'll be demanding our lien. Some of these trigger common law, common fund, equitable common fund things in certain states, which help us defend against the attorney's ability to recover fees and costs out of our lien. Okay, so you got 100% of your lien, but now you got to pay a third to plaintiff's counsel. Well, that can be defended against in most jurisdictions. Notice to a product manufacturer. Sometimes it's important to get notice out to a product manufacturer, although I can tell you that sending notice to, say, General Motors or Chrysler or a major General Electric oftentimes isn't going to produce a check. What it will do is it gets them working on the case and sort of removes an advantage you have. So judiciously give notice to product manufacturers and give always a notice to the employee. Find out if he's represented. There are state laws that have time limits and short fuses on things like intervening, filing suit. You want to know if they're settling. If they settle and you end up sending out demand letters to the third party for the next 20 years, and I mean, you can be prevented by latches from even recovering your reimbursement lien. So the most expensive letter never written in my career, there was a letter that was attempted to be sent to an appropriate party by a Lloyd's entity in a clear liability case involving Kansas City Power and Light and the failure of a large turbine engine that occurred some 15 years ago, and $55 million loss, zero recovery. It would have been a $55 million recovery had a letter gotten to the proper entity, and I just use that as a stark example. Excuse me one second. Okay, so this is a common mistake, and a lot of times notice isn't sent out because it's not known that notice is needed. There's such a thing as sending out notice too many times, and if you send out notice once, maybe twice, you don't get a response, take that as a message. Hey, I'm not interested in you. Hey, I'm going to try and deal with my life without paying you your money back. Accept it for what it is. It's rejection. Get active. Get MMA. You want to proceed to protect your subrogation rights. There's lots of turnover in our industry. And these are very complicated things to learn. That's why education is so important. We must keep training. On our website, we have one of the charts that I was showing you earlier. We have a municipal liability chart, one for the state, one for federal government, and one for municipal and local governments. It goes through the government immunity laws for every state, and that includes limitation of damages and notice requirements, when notice has to be given, to whom it has to be given. And you respond back, well, my days. You now are unnoticeable, so that's just as important. Okay, I'm going to, at this point, before we go to the next topic, which is crossing state lines for moral purposes, I am going to give you the trivia question. And we do this in our webinars. And I will read out a trivia question, and then you can email your responses. Jamie, is that right? Do they email them? In the question pane, she's telling me in my ear. We have to, if you have the answer, go ahead and put it in the question pane, and the first answer, the correct answer, will win an all-expense-paid trip to, oh no, wait, today it's one of our books. Any one of the books that you want, just tell Jamie and we will send them to you. Some of them are significant value, $400. If you guys have prohibitions against that kind of stuff, just tell us and we'll donate it to the company. But who doesn't want a book, right? Especially if you can't sleep at night. Trivia question is this. Who was the first television couple to be shown in bed together on prime time television? Who was the first television couple to be shown in bed together on prime time television? All right. I'll let you know later what responses we get. Let's move on to crossing the state line for immoral purposes. And this has to do with multi-jurisdictional opportunities and pitfalls. This is really one of our secret weapons. In the subrogation industry, this is one of the weapons that we can use that will really broadside even the most experienced trial lawyers. Some years ago, I worked for one of the best trial lawyers who ever lived out of Houston, Texas, John O'Quinn. I was associated with him on a number of cases and worked there through another firm. And he taught me how to try a lawsuit. He taught me why your client is more important than the facts in a case. And these are invaluable tools that I carry over to the subrogation world, and it's the reason that we refer to ourselves as trial lawyers for the insurance industry. We sort of tout ourselves as promoting time travel for the insurance industry. We are going to help turn back the hands of time for not only you, but for also your insured. Well, the U.S. Constitution says that each state is sovereign. They control the laws within their own borders. Obviously, vehicles travel back and forth between states. Jobs are done in different states. So you can have claims in which, let's say, an employee is injured in Georgia, but they were hired in Texas and received Texas benefits, and they live in Oklahoma. And now the first report comes in and you get a claim, and now is when your subrogation cap has to go on, not after you accept the claim, not after you start paying the benefits, not 3 weeks later when up pops a reminder on your calendar, send to subrogation. Now is the time to start effectively subrogating your claim. And what do I mean by that? Well, we often have a choice in terms of which states benefits in the terms of, in the case of work comp, we want to pay benefits under. And often that decision will make or break your ability to recover benefits. In the example I gave, an employee in Texas, accident in Georgia, employee living in Oklahoma, and a Georgia lawsuit is filed. If you go ahead and pay Texas benefits because you think that, you know, they may be more favorable than paying Georgia benefits, you have now foreclosed your right to recover in Georgia. Wait, what did he say? Yeah, there are states, and Georgia is one of them. There's some others up in the East Coast, where case law has said, look, unless benefits are paid under the laws of our state, a third-party action in our state, Georgia, will not honor a subrogation interest if the benefits are paid under the laws of a different state. So in the case of benefits paid under Texas and the lawsuit in Georgia, if, and that's a big if plaintiff's counsel is on his game, he will send you a letter and say, I'm sorry, are these Texas benefits? Please confirm. If so, you have no lien. Wait, I paid out $1.6 million. You have no lien, because when that claim first came in, when that notice of injury first came in, you made a decision to pay Texas benefits where a Georgia injury was involved. So that is one way that subrogation is a secret weapon of ours. We can actually design the law that we want to apply by making these decisions early on. Check with us if you have questions. So here's what normally happens when you have a multi-state situation: benefits paid under state A, accident in state B, lawsuit in state B. Now there's a question, okay, which state's subrogation laws govern your right to recover? If you have Iowa benefits and an Illinois action, Illinois tort suit filed, you now have a question, oh, can the employer be brought in? Because I think they might have been partly at fault. And if so, are we going to have an EL claim? Are we going to owe fresh money? Which laws apply are huge in helping you not only avoid claims for your insured, but also recovering your money. So there's three basic rules. One is lex loci delicti. Lawyers love Latin. It means the place, the law of the place where the deliction or the tort occurred. And that basically says that wherever the tort occurred, that's the law where we're going to apply. That is in extreme disfavor right now. There's only a handful of states that follow that. The more common rule is the most significant contacts rule. It says we're going to evaluate the contacts in both states. Where was the employee hired? Where was the work done? Where did the accident happen? Where were benefits paid under? We're going to make a decision on significant contacts. Which state has the most interest in seeing to it that their law is applied? There's also something known as the Larson rule, which is a rule which many states are adopting now. It says we're going to apply the subrogation law of the state in which benefits were paid. So even though it's an Illinois loss, Iowa benefits were paid, we're going to look to Iowa law and apply that. We're going to superimpose Iowa law onto the Illinois action, and the court will accept Iowa law. Why is this a secret weapon? Because think about it. Trial lawyers are not thinking about which state, under which state's laws were benefits paid. They're busy taking depositions and arguing and amending their complaints. All the while, we're sitting there in back triangulating as to exactly which law we're going to have apply. And there are some cases in which Iowa law may apply, but we're going to argue Illinois law applies, or rather not even mention it and just let Illinois law apply. So these are opportunities we have to game the system. And the reason it's mistake number 8, is because quite often, as you might imagine, it's not even considered, but it's there for the taking. You have to know the effect of the decision you make before you make it. Check with us if you have questions. This is complicated stuff, but it is well worth the time to work through it. When you open up that check for $815,000, knowing that had you not taken the time to think about the steps you were taking early on, you wouldn't have gotten it. It makes the difference between a full recovery and no recovery at all. So I'm going to, that brings us to mistake number 9, stepping over dollars to pick up dimes. Um, this is probably, if looked at merely in terms of how frequently it occurs, would probably be number 4 or 5. Um, it might be a state in which they allow an EL claim to be brought against the employer. It may be a case in which you have a large reserve on your comp claim and you are interested in waiving your subrogation rights in order to close out a comp claim or do a dollar contract in California or a CSA in states that allow it. There's nothing wrong with this. The right choice is the choice that derives the most benefit for us, the carrier, as well as our insured. And if it is wise to settle a comp claim and waive a workers' compensation subrogation lien, so be it. That's what we will do. But waiving a comp lien when it shouldn't be waived is a problem I see very, very frequently. I recently had a client waive a lien in a reasonably good liability case of over $700,000 where there was plaintiff's counsel, we were involved, litigation was going well, mediation was coming up, and I received word that they had closed out the comp claim. They had reserves of about $55,000, and in exchange they agreed to waive the subrogation lien. It was the brainchild of comp defense counsel, and I don't blame comp defense counsel. Their job, just like my job is to recover your subrogation dollars, their job is to get you out of that comp claim. Unfortunately, what happened in that case was they waived a $700,000 lien with about a 95% chance of prevailing in order to close out a comp claim worth about $55,000. Why does this happen? Well, for many reasons. A lot of times the recovery potential is simply not understood. In other cases, it's not understood because you are not getting the right sort of information. Whoever is representing you, and think back to mistake number 4 or 5, whichever is sleeping with the enemy, if plaintiff's attorney is representing you, let's just think for a moment about how diligent they are in providing you up to date with every step of the way. It's non-existent. So you're making decisions with no information, and I see this happening a lot. Probably it happens because we are talking real dollars on the comp claim, and often we look at the third-party case as monopoly money. Well, you know, it's money we've already paid. We're not paying out anymore. It's just nice to close the claim. There is also the human, self-centered purpose of, hey, I just want to close the claim so I don't have to deal with it anymore. You know, I'm like that. I've got files that I just can't wait to be done with. But I would get in trouble if I got rid of them or settled them for less than what I possibly could, merely because I wanted to close them. So the sad irony here is that had they waited until mediation, they would have received a majority of their lien back plus a significant future credit. And I happen to know what the case settled for. It settled confidentially, and I can tell you that they would have received a future credit of a lot more than $55,000. So had they waited just a few months, they would have recovered a lien and they would have closed the comp case, but they did so early without checking with subrogation counsel, probably at the behest of comp defense counsel. It is simplification, but at a cost. Again, this is actually a very good strategy. It's a comprehensive strategy. My clients have to think about manpower, how many employees they have, workload. All of these things go into the blender to come up with a prudent decision. That was not a prudent decision. And the future credit would have accomplished the same thing, but it cost them $700,000. So we want to coordinate the payment of benefits with third-party suit progress as well. What do I mean by that? There are some states where you aren't entitled to a future credit, and the case is about to settle, and I'm reporting to my subrogation claims client that we have mediation in 2 weeks. We project a good settlement. I should be able to get you your full lien back. Of course, there's no credit here in Arizona or whatever state that I happen to be in where that's the case, and I advise you of that. Well, if we had coordinated, if claims counsel knew, or if if the claims handler knew, or the claims handler also wore the subrogation cap. In other words, they swung both ways and actually did both sides of the job. They would know that they had a large medical payment coming up, and that it might behoove them to pay that, because they aren't going to get it back in the form of a future credit, but they will get it back in the form of a past lien. So there's strategizing here that needs to be done, and I see a lot of shortcomings in that area. It's true with EL claims, it's true in indemnity claims, it's true in California dollar settlement claims, and cases like California where you have a credit threshold. So do the math before you settle. Make smart subrogation business decisions. If you have questions, that's what we're here for. Smart subrogation equals better subrogation. So we're going to move on to the 10th mistake. But before I do, we have a winner of our trivia question. And the trivia question was, which primetime couple was the first shown in bed together? And the answer is the Flintstones. And Matt Pollys, P-O-L-Y-S, won the trivia question, and will be receiving a book of his choice. So congratulations, Matt. Thank you for playing. Also at this time, I'm going to ask you each to, in your question pane, type in the word here. If you are interested in CE credit, only if you're interested in CE credit, type in here, H-E-R-E, and submit it. Jamie will get it, and she will archive that and note for the Texas Department of Insurance that you were, in fact, here. All right, moving on to number 10. Subrogation in the Flat Earth Society, hiring the right experts. I actually, this is number 10, not because it isn't that significant. It actually is very significant, and it happens with a surprisingly large number of cases that we see, where there is no expert, or there is a bad expert, or there is an expert who is no expert at all. On our website, you'll find a chart that deals with qualifying an expert in each state, whether they have to comply with Daubert, and you can look there to determine exactly how careful you have to be with regard to your experts. But an expert is necessary in a lot of cases. They're necessary in product liability cases. They are sometimes necessary in premises liability cases. It's always good to show what the defendant should have done that they didn't do, and to get that evidence in experts in premises safety. If you have a parking lot security case, maybe there's an assault in a parking lot, you want an expert in parking lot security, where the lights should have been, how they should have been placed, what about security, was it adequate, was it inadequate, should there have been security when there wasn't because it's in a place of crime. We've handled a number of parking lot assault, rape, even murder cases for workers' compensation, where we went against the premises owner for inadequate security, even though it was the criminal act of a third party that caused the loss, and have made some great recoveries. And again here, I'll mention this, thinking back to the McDonald's case, we all get a little bit queasy when we think about that, or You know, the case where the guy was the burglar on top of the roof, fell through the skylight, and then sued the manufacturer of the skylight. You know, we hear about these cases. Some of them don't pass Snopes fact testing, but you know, we have to remember to put on our plaintiff's hat. We have to be a little bit aggressive and a little bit creative. The defense myopia that we all harbor within us as part of the insurance industry serves us well in that industry, but we have to recognize that it does have limitations, and it is expensive for us if we do not look beyond that myopia when handling subrogation. So medical malpractice cases, we see a lot of cases where an employee is receiving benefits and then all of a sudden, you know, they've been bugging you every 2 weeks and all of a sudden you don't hear from them. And, hey, Joe, what happened? How are you doing? Well, fine. I'm a millionaire now. Wait, what? Yeah, I made this third-party recovery against my doctor for, you know, me being hooked on these drugs that you keep paying for. Or, you know, the sacral nerve was nicked while doing spinal surgery, and now we have a paraplegic when there was simply, you know, a radiating nerve issue after a work-related fall. These are cases where we want to look and determine if there's medical malpractice. Experts are needed in cases involving improper loading, proper technique for securing scaffolding, proper fencing, like the livestock case we talked about. Flashback to the cut rate vendor mistake that we talked about, litigation guidelines that require we use XYZ investigation company, okay? And no matter what the loss is, no matter how big it is, the requirements are that you go to this guy and he sends out chief investigator, and they write a report with spelling errors and bad punctuation, and you get it back, and you know, it says something, well, we can't determine the cause. Well, remember that an origin expert, if we're talking fire loss now, an origin expert is different than a cause expert. The origin is going to find the origin of the fire. You do not have to have an engineering degree. You can be a certified fire investigator and a P921. You can follow the requirements to the T, and we have a new article out. I think it's on Claims Journal about NFP 921 and doing fire investigation and what is cause and what is origin. There really is no such thing as a cause and origin expert. You know, it flows off the tongue, but an origin expert's going to tell you where the fire started. They're going to look at fire patterns, drop-down fires, alligatoring, systemic fire spread, and they're going to point to an area and say, there's where it happened. They may be pointing right at a jukebox or at a Mixmaster or at a Sears toaster oven, but they're not going to be able to say that's the cause. They're going to say that's the origin. Then we have to have an electrical engineer or mechanical engineer or chemical engineer come in and say, okay, I looked at the cause, I agree this is at the origin, I agree this is the origin, here's the cause, and they come up with a wiring explanation. So, who is an expert? Look at our Daubert-Frye standards on the website. Junk science is everywhere. If you require us to use a quote-unquote expert from your list and they're not qualified, oftentimes that can do more harm than good. So be open to allowing us to say, well, we'd rather use someone else. If you have a claim and it looks like a significant claim, rather than going to your hired gun, call us and say, hey, this is what we've got. This is who we use. Do you have somebody better? Do you recommend we use someone else? This is all, remember, these mistakes, as I said early on, are to foster communication, good communication that results in good subrogation recoveries. So also in product liability cases, more and more states are now following the restatement third of product liability, which requires literally a reasonable alternative design. Your expert says, yes, it's defective, it's unreasonably dangerous, it has a design defect, here's a design defect. I will swear under oath in court that that's the case. Not enough in some jurisdictions. Now you have to have a reasonable alternative design. That requires design experience. So you're going to get Dauberted out. Your expert will not be allowed to testify if he does not have that experience. So a level 1 report written by a subrogation technician or a claims specialist, I see it so often. It's not an expert. And by the way, Get an oral report. I know it's easy. You pay a fee, you want a written report. I don't want a written report that says we can't determine the cause. It helps nobody. Talk to them first. Walk them through what's the cause, what's the origin, what is the product defective, do we have a recovery here, was there negligence in this premises liability case? Yes, there was. Will you put that in writing? Yes, I will. You want to make sure as to what's going to be in writing, because once it's in writing in some states, it's very hard to make it go away. So don't go with the path of least resistance. The other side won't, I can assure you that. We have an expert database that we have been collecting for 33 years. It includes more than 37,000 experts that have been indexed, cataloged, and are searchable by geography, discipline, and drumroll cost. So I know in your $14,000 case, you can't afford to pay an expert $20,000 to come out and give you a report. That makes no sense. That's the nature of subrogation. We're only as effective as we are cost effective, but product manufacturers know their products better than you. I still have a case involving a very expensive collector's Maserati that was worth a lot of money that caught fire sitting in a garage and destroyed it and the building around it, the house around it. And Maserati in litigation produced a schematic of the electrical wiring. And what they produced was hundreds of pages of just nonsense that made no sense at all, and the expert couldn't figure it out, ended up telling the client, look, there isn't a case here. Well, we hired a new expert, and we figured out that what they had done was printed off what should have been an electronic wiring diagram where there are links at the edge of each diagram that link to the next one. So it didn't make any sense in paper form, but nobody knew that until we had an expert that had worked on Maseratis and worked on Maserati wiring and knew the schematics. So it's important to get the right expert. Let us know if we can help you. There are a few honorable mentions. Never sign a release with indemnity. All right. I'm not going to go into a lot of explanation. Oh, but they're insisting on indemnity. Insist on no indemnity. There's really no indemnity needed. It's a rule we have. I'm not saying it's never done, but it should be kind of a rule. I see too often clients getting hurt because, oh, there's a hospital lien that came up afterwards. Well, don't pay it. Well, we sort of indemnified them when we settled. Oh, okay. We ignore the subrogation duty we owe to our insured. I mentioned that a little earlier, where we're actually working not just on behalf of the insurance company, but also on behalf of our insured to whom we owe a duty. And that duty is growing every year as legislatures realize that what we do in subrogation affects what they owe in premiums in years to come with their lost history and experience mod. So ignoring the small files, again, the temptation, we're all human. We all search the path of least resistance. If there's a path that is uncluttered and looks like it's easy to walk on, that's the one we take. But the other path led to where we wanted to go. So there's a choice to make. Don't ignore the small files. Most of our files are small files. If you have a firm or a company that says, well, we have a cutoff, we won't handle anything under 50,000, say, what? Don't use them. I mean, it's ridiculous. Most of the files are small files. I have files in our office that are three figures, $708, $214. I will lose money recovering those, but I want my clients to know that we are going after every penny. And because the small files are more common than the big files, they're important too. I mentioned earlier, don't give up too early once you have indemnity or waiver agreements. Don't. Even when you think you know that subrogation is gone, check with us. And lastly, grading on a curve. Those of you within the corporate entity, it's important that you grade yourself. You want to know how you're doing as a subrogation professional. Your employer wants you to know how they think you're doing as a subrogation professional. It's very easy to give yourself an A when you recover $115,000 on a subrogation suit and put it up on the tote board, unless you could have recovered $790,000. And there is no honest litmus test for determining when you make a good decision. Summary: subrogation must be cost effective to be effective. Shortcuts may be the right route to take. It's human nature to take them, but more often than not, they lead to a reduced recovery or no recovery at all. Subrogation is by far a better investment than any wager you can make in Vegas because you go into it knowing the odds. If you have a large catastrophic loss, you have subrogation. What in the world did Wickert just say? If you have a large catastrophic loss, you have subrogation. It is well worth the investment of time and energy to assume that you have subrogation when you have a catastrophic loss. It's well worth the time to look into it. And remember what I said early on, the 5 largest cases we've ever had in terms of subrogation recovery, each 10 figures or more, well, 10 figures. I'm sorry, 6, 7, 8 figures. Each of those subrogation recoveries were marked no subrogation, and I think that's very telling. So experience is the name we give our mistakes. Many mistakes are disguised as well-intentioned corporate efforts to save money. It's impossible to compare apples to apples. In many situations, it's like a fork in the road you take. You make a decision to move to a certain state, to marry a certain person, to take a certain job. That meant you didn't move to a different state. You didn't marry someone else. You didn't take a different job. Did you make the right decision? There are days when you think you didn't, but you will never, ever know because the other road could have been much worse. And so we're trying to choose the path that leads to the best outcome, implement the best subrogation practices and techniques that we have available. Don't delude yourself into think you're saving money when you're actually costing yourself money. And just remember that subrogation is an investment, and it's actually a very good investment. I've got a couple of questions. I'll go through real quick, and I see we have a bunch of questions. By the way, I wanted to announce that we have set a record, but we do a lot of webinars, and Jamie keeps track. If this is right, exactly 700 people in attendance, and the note says does not include conference rooms. If that's the case, that is at least 150, if memory serves me, more than any attendance record we've had. So I think that goes to show that we're not afraid to face our mistakes. We want to know what they are, and we want to try and fix them. So, okay, question. In Texas, how will I know if the waiver of subrogation these things fall into a row? Texas law says you have waived your right to subrogation, i.e. your right to sue in the name of the employee who was injured. You have waived your right to reimbursement, i.e. your right to get money back once the plaintiff recovers all that money. And thirdly, you have waived your right to a future credit. Your right to recover from others, as the endorsement form says, Texas courts have held that encompasses all 3 of them. It's a little unusual in a state like Texas that has been, and it used to be, one of the best states for subrogation, and now it's probably still in the top 10, but it's fallen from grace. Gregory has asked, what if the claimant has a right to choose the benefits that best benefit him or her, even though the loss occurred in Georgia. You know, that is a problem. I'm not suggesting that crossing state lines for moral purposes is something that we can take advantage of in every claim. And in fact, I'm not an expert. I know that there's a lot of symbiotic states that partner together. If you're injured here, you can claim benefits in this state. The West Coast, Upper West Coast has that. A lot of other states have it. I'm just saying, you know, be aware of it, and be aware that that's a potential. I'm not sure to what extent you want to start advising the claimant as to which state to accept benefits under. But I think it is important for us to know how it will affect us in the future. I hope that's a good enough answer. You know, bottom line is, there's really not a lot you can do if he has the right to choose. I'm just saying that from day one, that should be something you're thinking of. Okay, and what about day two? Okay, day two, you're handling the claim. Day three now, and you've got an attorney involved, and they want to try and settle the comp claim. Well, again, knowing what your rights are under the crossing state lines for moral purposes concept is real important, because if you are going to have some problems or potential problems enforcing a lien, you want to know that, in which case it might be a good idea to waive the lien in exchange for comp. And guess what? They might not be on the ball, and they might not know that the case of Johnson versus Comcar in Georgia prohibits your right to recover. So it can be used offensively even when adjusting the comp claim. Bottom line, knowledge is good in whatever shape or form. So that's important. Okay, question here. Penelope in Washington. I have a Texas case. Excuse me, let me click this open here. I have a Texas case involving a slip and fall and serious head injuries. Do I need an expert? You know, what I would suggest is give me a call or send me through the subrogation question feature. I'm gonna do this. I'm gonna show you one more time. It really is pretty slick, and we have lawyers, not just me answering these questions. We have a lot of lawyers. If you can go here, you can see you're on the website. Penelope, click here, ask a question. If you fill this out, question about Texas slip and fall, and click submit right here, we'll get it and we'll answer it. And I would like to know more about your case. I really can't say whether you need an expert. Sometimes you do, sometimes you don't. Texas has pretty good premises liability law. So there's some other questions here, and I will promise to answer those via email. I hate to go over too far. Thank you for attending. If you have any other questions, get in touch with Jamie about the webinar. Or any other questions, submit them, and we will have them answered and try and get them answered today. Thank you for attending, and have a great day, and think subrogation. Thanks a lot. Bye-bye.